Welcome to the webinar. Thanks for joining us today. We're going to be discussing the U.S. Uyghur Forced Labor Prevention Act and why you need to pay attention. For the webinar today, I'm Travis Smith. I'm the VP of Sales here at TRG. We're also going to have Felicia Donahue talking. She's our Marine Insurance Manager. And also, for this webinar, we are teaming up with FloraTrace. FloraTrace is a team of engineers, scientists, and trade experts helping companies meet evolving import and trade regulations. So this UFLPA is certainly an evolution in importing from customs. That's why we're all attending. And from FloraTrace, we have Taria Glostrad joining us and Brett Tipple. Two scientists. We couldn't be happier to have them here. As a reminder, you can find us on YouTube. If you haven't subscribed yet, go to YouTube and search Trade Risk Guaranty -TRG. Throughout the webinar, you'll be able to submit your questions. You'll see in your interface there's a questions box. Please don't hold back. Type in any thoughts you have. We will address them at the end of the webinar. In addition to questions throughout the webinar, there will be a follow-up email with a recording of the webinar and a very important survey. The survey will take you about less than a minute, but keep an eye out for that email and do reply to that survey. Do fill it out. As a quick reminder, this presentation is for educational purposes only and does not constitute legal advice. Now I'm going to hand it over to Taria. Taria, take it away.
So hi everybody, I'm Taria. I'm the Chief Operating Officer for FloraTrace. So FloraTrace provides supply chain risk management for importers. And the Uyghur Forced Labor Prevention Act, or for short the UFLPA, is a U.S. federal law with the goal of ensuring that American companies are not funding forced labor among ethnic minorities in the Xinjiang region of China, as well as eradicating forced labor in all global supply chains. So the goal, I think, after this webinar is that you should be able to then understand what the UFLPA law is all about, and then understand how this new trade law will affect you as an importer, and then understand what you can do to mitigate the risk for having goods detained by the Customs and Border Protection, or the CBP. And then finally, what to do if the CBP send you a UFLPA detention notice. So, FloraTrace have been in a number of meetings with the CBP to kind of understand how they will enforce the law and what they are looking for. And I think this quote from Eric Choi, who's the executive director of Trade Remedy Law Enforcement at the Customs and Border Protection, I think says it really well. It's incumbent on importers to do their supply chain due diligence before the cargo is detained. And part of the reason for that is that the time frame for providing evidence to the CBP is very short, of just 30 days. And that it's mandated that the importers then monitor the origin of materials. So the question then is, why now? Why now is there's a lot of different industries here and raw materials that is being targeted by the UFLPA, such as cotton, solar panels, tomatoes, and many other items. And one might think that, like, for example, a cotton shirt manufactured outside China will not carry any risk, such as a cotton shirt manufactured in Vietnam, for example. The issue, though, is that a large amount of the world cotton is grown in Xinjiang and then exported to other countries. So that shirt from Vietnam will fall underneath the UFLPA law if the raw cotton was grown in Xinjiang. So the law states that any material that's mined or grown or produced or manufactured in Xinjiang will fall underneath the UFLPA law. So it's important to realize that fact. I think that's something that when we talk to importers, they don't always realizing that, hey, the material could come from this region of China, but could then suddenly show up in a different country. So let me give you a little bit background on the UFLPA. So I already talked a little bit about the why, removing forced labor from the supply chain. But I think as an importer, it's very important to understand that, number one, there is a massive enforcement focused on this one trade law right now that came into effect in June this year. They're looking at hiring 300 new inspectors, and the CBP have received a large additional budget, and this is all for this one trade law. And we have some data over the last 2.5 months on the UFLPA enforcement, and it looks like the run rate right now is going to be at least $2 billion in withholdings over the next 12 months. And then this isn't just a US thing, but if you look at a lot of other regions like the United Kingdom, the European Union, Australia, and other regions are implementing similar laws as well. So this is something that's, it's going to become a bigger and bigger issue moving forward. So then when it comes to the next thing here, I want to talk about is the CBP enforcement for the UFLPA. And kind of the way this works is that, after a shipment have been presented for examination, the CBP then have 5 days to determine whether the shipment should be released or detained. And if the CBP determines that the shipment falls within the scope of the UFLPA, then CBP will issue a detention notice or a detention notice instruction that the importer need to then submit information rebuting the UFLPA presumption. So then after 30 days, the CBP is required to issue a final ruling on the goods admissibility. So there's really only 30 days there for the importer to provide the evidence. And so because of this accelerated timeline for review, the CBP has emphasized that the importer should be prepared to submit evidence in support of the request promptly and in accessible format. And then certain shipment, determined to be in violation of the UFLPA may also be subjected to seizure and forfeiture. And if you receive a detention notice, then you have kind of 2 options in addition to the re-export. You can ask for an admissibility review or an applicability review. And so far, no importers have, tried the admissibility review. The burden of proof, I think, is seen too high. I mean, it's extremely high burden of proof. But there have been a few successes around the applicability review. So most importers will choose to re-export and deal with the business interruptions and additional cost associated with the re-export. So next then, be proactive. That's really the key here. So there is a few things you can do to help prove your shipment should be allowed to enter the US. So number one, establish a due diligence program and careful assess your supply chain risk. And then 2, mitigate exposure to forced labor. This could be, look at new vendors, new manufacturers, or a different country of origin for some other raw materials that are maybe risky raw materials. And number 3, be prepared to respond to the CBP inquiries, and then to demonstrate that goods are not mined or produced or manufactured, wholly or in part with forced labor, as it's stated in the law. And then next here, we can look at a little bit at the numbers here. There is a staggering increase in the CBP detentions. Not to look at like all the fine details here, but we see since June here, there's a 4x increase in enforcement around forced labor. And as I mentioned already, the detainment of goods, with the current run rate will be at least 2 billion. And with this additional hiring of 300 inspectors, you could expect that to get even higher, way higher than that. So then next, know your supply chain, I think is the key thing here. And as purchasers or procurement managers, I think it's very important that they then make sure that the C-suite is aware of this changing environment and this new trade law, because it will potentially have a big impact on your company and your business. So then, finally, here with my slide is, FloraTrace provides importers with supply chain risk score. So we can think about this as like 3 different buckets. Like bucket one is kind of like the company risk score, where we look at like kind of the networks that your manufacturers or foreign exporters have. So this could be like things like ownership structure. Are the people who have ownership in some of these manufacturers that is on a no-go list? Who's the controlling entities of the manufacturers? And this is not just the first level manufacturer, but like all the way back. And then even things like co-location with known entities. Is one of the manufacturers co-located in the same building as a company who's on the entity list? That is something that also will raise a red flag with the CBP. So that's at the company level. Then you have the product risk score, where we basically then do a supply chain tracing of all vendors and suppliers, kind of all the way back into your supply chain. And then third, we also look at the material, the raw material, and trace the raw material used back to the physical location as to where it comes from. And so that's kind of like where we then create this supply chain risk score. And I will now hand over to Brett Tipple, our chief scientist for FloraTrace, and he will provide a closer look at our material mapping solution.
Thanks, Taria. Yes, a key component of understanding your risk in the supply chain is understanding where and how a good was produced. As Taria just mentioned, the UFLPA outlines several things importers need to do to be compliant with the UFLPA. And if you want more information about that, the Department of Homeland Security and Customs and Border Protections both have websites with documents and guidance there that you can find there. But this really breaks down into 2 different areas. The first is demonstrating that absolutely no forced labor was used in the production of the material. And the second is to prove nothing originated from Xinjiang. With the first bucket, some of the things that Taria talked about, sort of the due diligence systems, supply chain mapping, your supply chain management solutions, those sort of things help you demonstrate that no forced labor was used in the creation of the material. The second is you need to provide evidence to demonstrate that the goods were not mined, produced, or manufactured wholly or in part in Shenzhen. This is actually outlined on page 49 of the DHS strategy document. But the question is, how do you demonstrate where a good originated if there's no information attached to it? This is where analytical chemical approaches can come in. Material mapping makes it possible to identify the origin of particular goods or materials without knowing the deep inner workings of an overseas supply chain. This is because the innate chemistry of a material reflects where and how that material was mined or produced. Let's take a look at a material here, such as these coffee beans. To you and me, they are visually indistinguishable and they could be genetically indistinct. But on an elemental level, they may be quite distinct if they were grown in 2 different places. By looking at the patterns within the elemental makeup of a material, you can differentiate materials that, for all intents and purposes, appear identical. This sort of technology is regularly used in legal proceedings. Here's an example where a group of coffee growers in Kona, Hawaii used this type of information as part of their factual allegation in a case surrounding mislabeling of generic commodity grade coffee as coffee grown in Kona, Hawaii. In this case, the Kona growers knew about 85% of the Kona coffee out there on the world shelves was not really from Kona. And there was way more Kona coffee for sale than could ever be produced in the Kona region of Hawaii. The growers knew they were losing out not only on their bottom line, but also as people tasted the fake Kona coffee, they would be less likely to try Kona coffee again because the fake coffee tasted like regular old coffee. However, they had no way of demonstrating this without looking at the elemental chemistry of the beans themselves. This case remains ongoing, but the majority of the defendants thus far have settled. In this case, the material mapping program that was utilized by the Kona coffee growers really demonstrated quite clearly the origins of the coffees. So let's have a look at how this works. Every place on our planet has a unique combination of environmental conditions, soil compositions, and precipitation patterns. Plants and animals growing in these environments actually record these environmental conditions within their tissues, and specifically within the chemistry and the elemental composition of their tissues. Similarly, the chemical composition of geologic materials, be that rocks or minerals or ores or oil and gas, also contain unique combinations of elemental patterns and relationships. These combinations and patterns of elements yield unique fingerprints indicative of where that material originated on the planet. By using statistical methods similar to those used in genetic analysis that folks might be familiar with, the origin and authenticity of a material could be determined. So the UFLPA encompasses goods and materials originating from Shenzhen. However, DHS and CBP have called out specific types of materials in the initial rollout of the Act. These include cotton products, tomato products, polysilicon, and apparel in general. If you're an importer of these sorts of materials, you're probably already aware of the issues around forced labor regarding these materials, because all of these have been covered by previous withhold release orders. So the UFLPA has much broader scope than these specific withhold release orders in the past. However, there are a lot of additional agricultural and manufactural goods produced in Shenzhen, and we, as well as many other experts, anticipate other specific goods and materials will be added to the CBP's targeted list. They may actually already be on there that we just don't know about that. But remember, the UFLPA requires evidence to demonstrate that goods were not mined, produced, or manufactured wholly or in part in Shenzhen. So think back to that example that Taria gave of a finished garment that was finished in Vietnam. You still need to understand where all the raw materials originated for that garment, even though it was made in Vietnam. So if any of that raw material originated in Shenzhen, it still may be covered under the UFLPA. Along the same lines, importers need to understand that if their imported goods is a mixture or a blended material, if any of the components in that mixture originated in Shenzhen, it could also be subject to the UFLPA. This is like a really important component of this geochemical fingerprint and material mapping, because we can identify mixtures of these sorts of materials, and we can identify where those components and those mixtures are originating, so we can help address sort of those issues. So material mapping provides an independent analytical scientific tool to probe into your supply chains. It allows you to measure and track compliance and identify changes in sourcing that you might not be aware of without sort of this underlying program. With a material mapping program, you can not only monitor your tier 1 suppliers, you probably have a pretty good relationship with them and know a lot about what they're doing, but this mapping, material mapping, allows you to probe deeper into your 2, 3, 4 level suppliers, way deeper into your supply chains. And this allows for both detection and deterrence of non-compliance within your supplier. So having the knowledge that you have this mapping program in place that's going to really deter these second, third, fourth level suppliers from doing something that's out of compliance. In regards to the UFLPA risk, material mapping and origin verification alone is really not sufficient. These technologies need to be coupled with supply chain mapping and your overall due diligence around your sourcing. So when you're thinking about your supply chain risk in the UFLPA, it seems at this point it's not really if, but rather when. And for this reason, you really need to be proactive, but we've said that a couple times now. And with the accelerated timeline for review, Customs has really emphasized that importers should be prepared to submit evidence promptly in easy to read forms and in plain English so they can understand what's going on. And basically they're saying that you need to be proactive if your goods are coming from Shenzhen or produced in Shenzhen across the board. There are other reasons why importers should really, importers need to maybe think about their supply chains in a little more detail. The recent Inflation Reduction Act has outlined some tax benefits for domestic production, particularly in the renewable energy sector, as well as thinking about sort of corporate social responsibility and sort of the ESG metrics that your company might be putting together. This sort of information can support those, as well as sort of in the example of Kona, help reduce the risk of product fraud. So with that, I'll turn it over to Felicia to give you an insurance perspective on the UFLPA.
Thank you. So to get started on talking about insurance and how this ties into everything, the first thing I want to talk about is just a bit of risk management and what your options are, because there are a few different strategies out there. Obviously, there's going to be risk for every importer. So the first choice that an importer or any business has is to avoid the risk altogether. So that's either stopping or never starting something that causes the risk to come up. So in this instance, that would be choosing to stop importing altogether and maybe you only source domestically. It's probably not going to be an option for most importers. It's what they do is they import. So another option is to prevent, which is doing things strategically to reduce the likelihood of something happening often. So good example is due diligence, making sure that you are checking your supply chain. Another option is to reduce the risk. So that is taking steps to prevent it being a big issue when something occurs, because it's going to occur. And reducing the severity. So good example is having your supply chain vetted and sourced so that you can quickly prove to U.S. Customs your supply chain. Another option is transfer, which is basically shifting the risk from your company to someone else. The most common example is insurance. An insurance company agrees to take on your risk in your stead. And then the last is retain, which is basically accepting that, this event or this financial issue is inevitably going to happen at some point, and planning ahead and setting funds and resources aside in order to deal with it when it does occur. So next, I'm going to talk a little bit more about specifically the transfer option of insurance. And I'm going to focus mainly on marine cargo insurance, but there are other insurance products out there that you probably will need to talk to your broker or your agent about. A lot of importers assume that marine cargo insurance covers certain things that it really doesn't. And it makes sense that it doesn't, but it also makes sense why you would assume that it does. So the first example that really applies to this particular legislation is delay. Most marine cargo insurance policies exclude delay because it's not physical loss. It's just taking longer to get there. You still know where it is. You still know who has possession of it. Um, the other thing that marine cargo policies typically exclude is any proximate loss caused by delay. So if delay leads to something no longer being usable to you by the time it gets to you, it's still considered excluded under most marine cargo insurance policies. The one exception to that being if you have temperature control coverage and the temperature control machinery breaks down during the delay. That's really the only exception to delay not being covered. The other issue that might come up with this legislation is your cargo being rejected. If you can't show that it's in compliance, it will have to be re-exported back to the country of origin. And there are costs associated with that. And marine cargo insurance does not cover rejection. The cargo is not broken or lost. It's just not legally allowed into the country, and insurance cannot cover an illegal shipment. You can, in theory, pursue coverage for rejection. However, the market is very limited, and it's typically a very costly type of coverage to pursue. So, having talked about those two types of situations and how marine cargo insurance realistically will handle it, I want to talk a little bit about what you can do right now. So, like I already talked about, first line of defense is to prevent and reduce the likelihood of a risk costing your company money. So biggest thing you guys can do right now is put in your due diligence. Make sure that your shipments are compliant. Make sure that you have everything documented and you are prepared to verify your supply chain if your goods are held. You need to expedite that process in order to reduce business interruption, reduce lost sales, reduce the likelihood of goods spoiling or going bad. The other option that's out there is to transfer, which is purchasing insurance. Currently, I am not aware of a product on the market that will cover this situation of your goods being held or rejected. I would expect in the coming year or two for similar coverage to be developed by insurers, similar to the Lacey Act coverage. For those of you who aren't familiar, the Lacey Act is a government regulation that is meant to prevent and control illegal harvesting of plants or animal products. So very similarly, you must be able to verify the entire supply chain to prove that your lumber was not illegally harvested or that animal's hide was not illegally poached. And it's completely on the importer to be able to verify that. There are coverages out there for Lacey Act rejection or delays or that sort of thing. So I would expect a policy to be developed by the market in the coming years. But it can be tricky to obtain. So there's only a few insurers out there that currently offer Lacey Act coverage. So I expect it to be the same. And then the last option that we talked about is to retain. Like FloraTrace has already said, it's not really necessarily a question of if, it's a question of when. So plan ahead now, set funds aside, make sure you have plans in place for if your goods are held. And my last bit of advice for you guys is really make sure if you have concerns about business interruption insurance, lost sales, if you're concerned about your goods going bad, talk to your current insurer or your agent or your broker. Talk to them about your needs, talk to them about your concerns, and talk to them about how you are being proactive, so that you can come up with a completely holistic risk management strategy with your insurer. Don't rely on everything just being covered by insurance. Make sure you have a plan and you know exactly how things will shake out if and when something happens. So with that, we're going to give you guys a few minutes to submit your questions.
Yeah, thank you, Felicia, Brett, and Taria. As Felicia mentioned, we're going to open this up to discussion with questions. Remember to submit your questions in the question box in the webinar interface. While we collect questions from the audience, I'd like to take a moment and talk about TRG. Since '91, TRG has provided U.S. customs bonds as well as cargo insurance from our headquarters here in Bozeman, Montana. On the customs bond side, we work on a direct-to-importer basis, allowing the client to secure the bond in up to a 5-year term. On the cargo insurance side, we write through the Lloyd's of London market, AXA XL, Liberty Mutual, and Hudson Insurance primarily. Our coverage can include international transit, door-to-door, domestic, as well as your goods while they're sitting in a warehouse, whether you own it or if it's a third-party warehouse. Our annual policies start at a very low $750 for a year of coverage and go up from there, depending on exactly what you have going on. Our policies are written specific for each client, so we collect the details and the shipping practices you engage in and provide coverage that we can. Hopefully it's perfect coverage for what you need. So I see we have a couple questions right now. The first question, how long is this law going to be in effect? Brett or Taria, do you want to talk about the expectation for how long the Uyghur Forced Labor Protection Act will be in effect?
Yes, I'm sure if Brett, you want to take that, I can take it as well. I think that there's two components to it. One is, I think the initial time, I think is 8 years, or till forced labor is eradicated from the supply chain.
I'd also add that there's similar legislation developing in other countries around the world as well. The EU is moving towards something similar as well. So yeah, the UFLPA here in the US is 8 years or until forced labor is eradicated. So yeah.
Okay, yeah, and I mean the big wild card there is until forced labor is eradicated, and in a perfect world that'll happen quickly, but we don't see this law going away. And this is a good question. You know, so many of our webinars either talk directly about anti-dumping and countervailing, but this attendee asked if FloraTrace's tracing science can help with anti-dumping or countervailing.
Yes, absolutely. Similar sorts of questions surrounding the origin of materials. Some very large fraud cases have been around anti-dumping, particularly with food products, honey, and steel. And yes, absolutely. The geochemical technology allows for the origins of those sorts of materials to be identified and can help establish an understanding of where something might have came from. So absolutely, Trevor.
Okay, and Felicia mentioned the Lacey Act. We have an attendee asking if FloraTrace's approach can be applied to the Lacey Act, which is pretty interesting because that law has been around for over 100 years, and the FloraTrace science is still new. And the Uyghur Forced Labor Act is triggering FloraTrace to apply your science to the UFLPA, but I'd imagine your approach can also provide verification for importers concerned with the Lacey Act. Is that true?
Yeah, that is true. Very interesting stuff around the Lacey Act. I'm not aware of this technology being applied in a broad sense, like we're describing with the potential for the UFLPA, but things like ivory, knowing when the ivory was harvested. These sorts of technologies can definitely help answer that. Same thing with, furs and, animal derived products.
Perfect. I don't see any other questions at this time. Thank you for attending. You'll see on the screen, you have our email address there. If you have any additional questions, reach out. If you have feedback on this webinar, there's FloraTrace's email, there's our email. You'll find Trade Risk Guarantee on YouTube, Facebook, our homepage is there. There's our blog. Please visit our blog. There's lots of great content there. Keep an eye on your inbox for that follow-up email with the recording of the video. We will also include that survey. Please take a minute and complete that survey. And again, thank you for attending the webinar. Have a great week.